Dupex. This is the second of the course of revision lectures on equity and trusts. In this lecture, what I'm going to do is look basically at what a trust is. In other words, the definition of a trust. That involves trying to describe what a trust is. It's about as easy as describing what an elephant is, probably. And in trying to explain what it is, I'll contrast it with other things so we can try and get an understanding of what a trust is all about. Basically, a trust is an obligation which arises in equity, and this takes us back to my first lecture. It arises in equity as opposed to the common law, which binds someone to deal with the property over which he or she has control for the benefit of other people. And those other people may enforce the obligation. So, if you would go back to my example I gave in the previous lecture, I took an example of someone, myself, who transfers property to a trustee and tells that trustee to hold property on trust for other people. In the example I gave, it was for law students. So when that property is transferred to the trustee, he or she has an obligation to deal with the property over which they have control for the benefit of those people whom I've designated as being entitled to receive the benefit. Law students at the University of Poppleton, the example I gave. And if the trustee deviates from the obligation or fails to observe the obligation, then we can say they're in breach of trust, and it further follows from that that the beneficiaries can enforce the obligation. In other words, if the trustee pays out, instead of paying out the money or the property to law students at the University of Poppleton, pays out the money to management students at the University of Poppleton, then they're in breach of trust, and the law students can enforce the obligation against the trustee and compel them to observe the obligation. And if they paid out money wrongly to a wrong group of people, then unfortunately for them, they've got to make good that deficiency because they're in breach of trust. And they must make, as they say, restitution to the trust. In other words, they've got to put back what they shouldn't have taken out. So that is basically what a trust is. But it is, to develop that further, it is a relationship of a fiduciary character. And what I mean by that is that the person who has the obligation, the trustee, has a fiduciary relationship with the beneficiaries. And that relationship arises in relation to the property which they hold, and I stress that it's the property they hold, and they have a duty to deal with that property for the benefit of the other people, the beneficiaries, the third parties. But I stress that the relationship is with property, because in the examples I've given, property, be it shares, be it land, be it money, is transferred to the trustee, and the trustee is obliged to deal with that property for the benefit of the beneficiaries. So it's not merely a question of a personal liability or personal duty, it is a duty in relation to property. And the property which is transferred to, or vested in, as we should say, the trustee, is called trust property. In other words, that property is, if you like, infected with or affected by a trust. Now that's important, and I shall come back to that later, but it's important to bear in mind that the property itself is the subject matter of the trust, and the trustee is obliged to deal with that property consistently with the terms of the trust. So, to repeat the point I made earlier, if the trustee who's holding holding the property on trust for the benefit of law students at the University of Poppleton, if the trustee transfers property to management students at that university, that is in breach of trust, and the trustee must make restitution for what has been lost to the trust. Now, as I say, it's not always easy to describe what a trust is, and so it's probably a good idea to contrast it with other concepts so we can try and form a clearer view of what a trust is. I want to look at 4 different types of relationship with which I want to contrast a trust. Firstly, I want to look at what is called a bailment. and trusts contrasted with bailments. A bailment is basically a transfer of possession, whereas in the case of a trust, when the trust is created, the trustee owns the property which has been transferred to them, whereas a bailment is a transfer merely of possession. So if, for example, I lend a CD to a friend of mine, or if I take my jacket in to be cleaned at the cleaners, what I'm doing is transferring possession. I'm transferring possession of the CD to my friend whom I'm lending it. I'm transferring possession of my jacket to the cleaners who are going to clean it. And in both cases, the person who has the transfer of property, who receives the property, is not the owner of the property. They are merely the possessor, or to use the correct terminology, the bailee of the property. As I say, a trust involves a transfer of ownership and not merely a transfer of possession. And that means that when I, as settler, create my trust in favour of law students at the University of Poppleton, I no longer own that property. It is now owned by the trustees, and I cannot get it back. So a trust involves a transfer of ownership, and that emerges from the discussion of contrasting it with a bailment. Secondly, there is the distinction between a trust and a debt. As we know, a debt arises where you go to someone and ask them to lend you money for a certain purpose. Quite often, or quite normally, it's you go to the bank and you ask the bank to lend you money because you want to buy a car, and the bank says, yes, we'll lend you money to buy the car. Now, in general, the fact that the money has been lent to you for the purpose of buying the car will not create a trust. If you go back to the example of the loan for the purpose of buying a car, your relationship with the bank will be a personal relationship, and if you breach the terms of the loan, it'll sue you for the money. The car doesn't come into the question at all, even if you go bankrupt, in general. But there have been certain circumstances where money has been lent for a specified purpose, and the court has concluded that, in fact, a trust came into existence. These are called Quist-Close trusts, and they arise from a case called Barclays Bank Limited versus Quist-Close, which involved a situation where a company was in financial difficulties, and it went to a bank and asked the bank to lend it money to pay the dividends which it was due to pay on its shares. And the company which lent the money said, which in fact called Quist-Close, Quist-Close said, we will lend you the money on terms that, or on condition that, the money is used to pay the forthcoming dividend. And they lent the money to the company. The company put the money into a separate bank account at Barclays Bank, and it was made perfectly clear to Barclays Bank that it was earmarked for a specific purpose, that it was to be used to pay the dividend, and so the separate account was opened and the money was paid in. The company, unfortunately, before the dividend fell to be paid, went bankrupt. And so the question was whether the money which had been lent by Quist-Close should revert to Quist-Close or should be swallowed up by Barclays to deal with the general indebtedness of the company because the company was in overdraft to Barclays Bank. So it's basically a tussle between Barclays Bank and Quist-Close, Barclays saying the money is ours and should be used to offset the overdraft, Quist-Close saying, no, we lent this money for a specific purpose and no other purpose, and we are entitled to have that money back. And of course, as you can see from that, if the argument of Quist-Close succeeded, effectively it would give Quist-Close priority in the bankruptcy. And the House of Lords in that case said that in such a circumstance as that, where it's being made perfectly clear that the money is to be advanced for a particular purpose, and there's an intention behind it that it should be used for that purpose, the House of Lords said that in that case a trust would have been created, and when the money was transferred into the separate account of Barclays, Barclays could not take priority, and the money was held by Barclays on trust to return it to Quizclose in the event that the dividend wasn't paid. So, and that is precisely what happened. That was the conclusion of the House of Lords. The money was held by Barclays on trust to return it to Quizclose. Part of the reason for that is that, in fact, when the separate account at Barclays was opened, it was made perfectly clear to Barclays that it was earmarked for a specific purpose, and Barclays couldn't say that they didn't know about it because they'd been told that that was why it was being opened. And so it would have been inappropriate to argue that they didn't know about it. And something, if you read some of these cases in this area, you'll see that the judges often talk about the conscience of the person receiving the money being affected, and the corporate conscience, if you like, of Barclays was affected in this case because they were on notice that the money was earmarked for a purpose, and they couldn't effectively argue that they were able to take free of that purpose. Quizclose trusts have cropped up in a number of subsequent cases. Quizclose itself was decided in 1970, and subsequent to that, in the succeeding years, there have been quite a number of cases which have developed that original idea, and so it remains a very important case in this area. The third concept, which I want to contrast with a trust, is the concept of a contract. Now, a contract may well involve three parties, like a trust may. If I agree with you that if you do something, I will pay you for it, then that is a classic contract. It involves two parties, you and me. I'm the contracting party with you. I agree to pay you if you do something for me. But if we then change that example to a third party, I agree with you that if you do something, I will, instead of paying the money to you, pay the money to a third party. Now we've got three parties involved. Now in that case, the classical doctrine of privity of contract would say that the third party cannot enforce the contract. In other words, you do your part of the bargain, whatever it is. I fail to pay the third party. But the problem is that the third party, not being, as they say, privy to the contract, cannot sue on it. Of course, if it was you, in other words, if it's just a bipartite agreement, I say to you, if you do something, I will pay you for it, then of course you can sue me for breach of contract. But if it's a third party, then the third party can do nothing about it. Now, to an extent, that doctrine was changed by legislation in the late 1990s, which enables third parties in some cases to sue and effectively reduces the impact of the doctrine of privity of contract. Nevertheless, that holds good as a matter of general principle. Now, however, if you think of the three parties involved in a trust, once the trust has been properly set up, once the ownership of the property has been transferred to the trustees, and the trustees hold that property on trust for the beneficiaries, although the beneficiaries are third parties, and as I've said before, have no direct relationship with me, nevertheless, those beneficiaries are able to set up the trust and to sue on it if there's a breach of trust. So, whereas the third party in the contractual example could not sue, the third parties in the trust example can sue because, as I said before, they can hold the trustee to account for what the trustee has done or not done. And if we have a trust which has come into existence, the beneficiaries, who are third parties, actually do have rights. The fourth concept, which I want to contrast a trust with, is a power. Trust and powers. Now, a trust, as I've already indicated earlier in this lecture, a trust is an obligation, whereas a power is not. The classical definition of the difference between the two, and you'll see this in the books and in the cases, is that a trust is mandatory and a power is discretionary. Or sometimes they say a trust is imperative and a power is discretionary. And what that means is that when you are subject to a trust, you have an obligation from which you cannot depart. Whereas with a power, you have a choice as to whether and how you exercise the power, but you are not obliged to exercise the power at all. And so, in the case of a trust, if you go back to the example of holding property on trust for law students at a particular university, the trustees are obliged to hold that property on trust for those law students. And there is an obligation which is enforceable against them and from which they cannot depart. In the case of a power, as I say, gives a discretion. If I give you some money and say it's up to you what you do with it, but if you'd like to buy some drinks for your friends, then you go ahead, then basically I've given you a power over how you use that money. If I said to you, you must use that money for a certain purpose, then it might be that I've created a trust. But if I just say to you, there you are, there's some money, you can use that money as you want to, then basically I've given you what we would call a discretion. I've given you the choice. You can do what you like with it, including pocketing it for yourself. So a power is discretionary, where the trust is obligatory or imperative. Now, that is an important distinction, because again, as with the other contrasts I've made, the fact that the trust is obligatory means that if the trustee deviates in any way from it, they will be in breach of trust. Well, having uttered those introductory remarks and tried to define what a trust is, what I will do for the rest of this lecture is just to set out the requirements for a valid trust, which I will look at in more detail in the succeeding lectures. A valid trust, to create a valid trust, we need a number of ingredients, and those are basically 5. Firstly, the trust must satisfy the requirements of certainty. Secondly, it must satisfy the relevant formalities. Thirdly, it must satisfy the rule of perpetuity. Fourthly, it must satisfy the beneficiary principle. And fifthly, it must be completely constituted. Now, I'm going to look at those requirements in more detail in due course, but I will just say a little bit more about them in the remaining moments of this lecture, just to indicate to you what they're all about. But before I do so, I should just point out that these requirements apply to private trusts. They don't apply to public or charitable trusts, which by and large aren't subject to any of these requirements. The requirement of certainty, which I'll develop in the next lecture, says that there must be what are called the 3 certainties: certainty of words, certainty of subject matter, and certainty of objects. In other words, the words used to create the trust must be words which are sufficiently clear and certain to do so. The subject matter must be sufficiently certain to enable the trust to come into existence. It's no use just saying, oh, I'd like to give some of my property to my trustees. That simply won't work. And the third certainty is certainty of objects, in other words, certainty of beneficiaries. The group intended to benefit must be sufficiently certain. Now, the third certainty, certainty of objects, is linked with the 4th requirement I mentioned earlier, the beneficiary principle, which I'll come back to in a moment. So we've got the 3 certainties. The second point is that the setting up of the trust, for the trust to be valid, it must satisfy the relevant formalities. Now, by that I mean it very much depends on what the subject matter of the trust is. Land has certain specific formalities set out in the Law of Property Act 1925. Other properties, or other types of property, don't necessarily have such a stringent requirement as land, but they may have requirements, for example, of writing. Thirdly, the trust must satisfy the rule of perpetuity, and basically what that means is the trust must not go on too long. On the other hand, if it's a charitable trust, it can go on forever. The 4th point is there must be a beneficiary. The beneficiary principle must be satisfied. And then 5thly, as I've said, the trust must be completely constituted. And what I mean by that is that there must be a transfer of ownership to a trustee or to the trustee, and there must be a declaration of trust. The two go together. You cannot have one without the other. There must be a transfer of ownership to the trustee, and the trustee must be declared to be a trustee, and there must be a declaration of trust. And one of the things we will need to look at in due course is what happens if any of those ingredients or requirements is missing. The final thing I want to say in this lecture is I want to talk about the types of property that one can have. Basically, property divides into two groups. It divides into what is called real property and what is called personal property. Real property is effectively land, and as I've just indicated, there are certain specific requirements in relation to land. Apart from that, apart from real property, then the second one is personal property, which is basically property other than land, obviously. Personal property divides into two groups. The first group is what is called chattels real, and the second group is what is called chattels personal. Chattels real are basically leases. If you have a leasehold of premises or property, that will be classified as chattels real, which of course is a subset of personal property. The other subset of personal property is chattels personal, and those are again divided into two groups, what are called choses in action and choses in possession. And one can make the distinction effectively between intangible property and tangible property. A chose in action is something which you can't see and which you need to enforce by means of an action. And by action I mean action in the court. So, for example, copyrights, intellectual property rights are generally intangible property, whereas on the other hand, a chose in possession is something which is tangible or holdable. So one's clothes, a pen, one's glasses, a telephone, a camera, those are all choses in possession, which you can effectively possess. You can hold them in your hand, whereas, as I say, a chose in action you cannot hold because it's intangible. The point of giving those examples and the point of setting up the classification of property is that any property which is known to the law is capable of being the subject matter of a trust. So, for example, an author who is entitled to royalties by virtue of a book, if you take J.K. Rowling, for example, she is entitled to the copyrights in her books. Now, the fact there is a copyright in a book, that's intangible. The book itself is tangible, but the copyright is intangible. But she would, as Agatha Christie and other authors have done down the years, create trusts of those copyrights, and the income generated in terms of royalties from the sales of her books and the film rights and so on and so forth is capable of being held on trust. And so the royalties generated from the copyrights will be payable to whoever she destines as the intended beneficiaries. Anything known to the law as property is capable of being the subject matter of a trust. That's the important point to bear in mind at the end of this second lecture.